first webinar from Hare Court. This month will be on wrongful trading, the overlapping provisions of directors' duties, and we'll finish with a summary of the wrongful trading reforms in the Corporate Insolvency and Governance Bill. I'm Helen Pugh and I will be speaking first, and then I'll hand over to my colleague, Olivia Wybraniec. So where is the wrongful trading provisions? What are we talking about? We're talking about section 214 of the Insolvency Act. This is within a part of the Act which generally deals with a number of provisions of directors' malfeasance, ranging from the summary remedy in 212 right down to the restriction on the use of similar sounding company names. This is section 214, and the way the wrongful trading laws are set out are, firstly, there's a general permissive power in subsection 1, which provides that the court may make a declaration that somebody's liable to contribute to the company's assets. Subsection 2 sets out the liability triggers, which have to be met if wrongful trading liability is to attach. Subsection 3 is then a defence, which a director has the burden on if he wants to escape liability if the criterion 2 is already met. Subsection 4 helps us with the interpretation of subsection 2 and 3. So moving on then to what is wrongful trading. And the answer is that there is no statutory definition of wrongful trading. That is deliberate. There was a lot of discussion before Parliament about various proposed wordings, but the attitude of the legislator was that wrongful trading should not be narrowed, it should be a broad offence. In practice, what that's meant is that the court has defined the substance and what amounts to wrongful trading, and in practice what has happened is the definition has perhaps been narrowed beyond what Parliament originally intended. In particular, the courts have had to decide what amounts to the circumstances when a director ought to have known that there was no reasonable prospect of avoiding an insolvent liquidation, and also they've been left to determine when a director meets the standard of the defence. So when does wrongful trading apply? It applies once a company has gone into insolvent liquidation or insolvent administration, and then there are similar provisions elsewhere which deal with insolvency, partnerships and insolvent LLPs. Who can be liable for wrongful trading? Well, unsurprisingly, the answer is directors or a former director of the subject company. It includes a shadow director, and it probably includes a de facto director, although that is based on case law rather than the statutory provisions themselves. The key is that the director must have been a director in whatever definition we're using at the moment of truth, so at the relevant time. There is no accessory liability for wrongful trading, and that differs from the fraudulent trading provisions in section 213. Who can bring a claim? On the application of the liquidator, and it can be one of the powers which can be assigned by a liquidator or indeed administrator if we're talking about administration. What do I mean by the moment of truth? Well, this is set out in subsection 2 of section 214, that with the help of the interpretation subsection 4. And the moment of truth test is when the defendant knew or ought to have concluded that there was no reasonable prospect that the company could avoid going into insolvent liquidation or insolvent administration. The key there is no reasonable prospect. It's judged then from the perspective of a reasonable, diligent person, but the test is not just objective. So the objective part is in subsection A of subsection 4, and so the hypothetical person is given the general knowledge, skill and experience that may reasonably be expected of a person carrying out the same functions as are carried out by the director. But the subjective aspect comes next, and that is that the hypothetical person is given the general knowledge, skill and expertise and experience that that particular director has. So the objective standard is a minimum standard, but if the director has any particular experience which is relevant, then that will in effect raise the standard against which that director will be held. So case law suggests that what is reasonably expected will differ depending on the size of the company and whether the company has a large structure in place that can deal with accounting procedures, compliance and so forth, or whether it's effectively a one-man shop or somewhere in between. The key is the company does not have to be presently insolvent. So that's quite important. The company, at the point the moment of truth is reached, might not actually be insolvent. The question is whether it has any reasonable prospect of avoiding becoming insolvent. Conversely, temporary current insolvency does not trigger liability either, because the key is whether it will be able to trade out of that and avoid an insolvent liquidation. And when we're talking about insolvent liquidation or administration, we're talking about insolvency on the balance sheet basis rather than on the grounds that a company is unable to pay a statutory debt demand or so forth. The moment of truth test has been paraphrased as being equal to inevitable that a company will go into insolvent liquidation, and that has been held to be certainly not too high a threshold, so it is a suitable paraphrase. This is a case study that I thought it would be useful to go through. Ruben and Gunnar. You'll see that, so if I just get all the facts up on the slide, you'll see that the company traded at a loss since incorporation. Sadly, that's fairly common. There were two directors who effectively turned to a third individual for investment. He made a number of promises about where the investment was going to come to fund the company. His promises repeatedly failed to come to fruition. Sometime later, there was one remaining assurance on the table from the third director, and it was effectively that the company's business would be sold to Nuco, which could be floated on the NASDAQ, resulting in a substantial payment. The two brothers, the two directors, sought the advice of a chartered accountant who effectively said that if they believed in this third director, then that would mean that the company was not insolvent. Sadly, the company went into CVL anyway. Mr. Justice Etherton said this. He said that in effect, that the promise from the third director was fantastic, and that no reasonably competent director would have believed in this particular promise. As to relying on the chartered accountant, he pointed out that the advice was predicated on the belief that the third director would provide the necessary funding, and in light of the two original directors' knowledge that promises had repeatedly failed to materialise previously, there was no reasonable basis for the belief that it would be any different this time. And that's quite a useful decision, because it shows that a director can't rely blankly on a third-party advisor. A defence. The defences in subsection 3, as you can see, the key is that the directors have to take every step with a view to minimising the potential loss to the company creditors. The director is deemed to have actual knowledge that the moment of truth has arrived. So once liability has been established according to subsection 2, there can be no rerunning of that argument at the subsection 3 stage. So the defence actually, on the face of it, is a high hurdle, because the director has to take every step and the loss must be minimalised, not just reduced. Re-Rouse, which we'll come on to again later, has also held that the director has to show two things: has to show that continued trading was intended to reduce the net deficiency, and that it was designed appropriately to minimise the risk of loss to individual creditors. So it's not enough that a few creditors have their loss minimised if there's one particular creditor or a couple of creditors to whom the loss increases. The directors do not have to succeed in their aim of minimising loss. The test is whether they subjectively took every step with a view to minimising that loss. Steps could include consulting with bankers, preparing management accounts, preparing profit-loss forecasts, consulting with third parties, and engaging with creditors. It will be relevant where you've got two directors or more, whether the one director was urging the others to take steps and being thwarted, for example. The burden is on the director to prove the defence. It's also worth pointing out that section 1157 is not available to a wrongful trading claim, and this is the defence which is usually run by directors in response to breach of duty claims, where they claim that they have acted honestly and reasonably and also in all the circumstances to be fairly excused. Remedy then. So subsection 1 provides the court with a broad discretion on remedy. Case law, however, suggests that the remedy is in fact quite narrowly circumscribed. The case law really begins with Mr. Justice Knott, who emphasised that the provision is compensatory rather than penal. The additional directions which a court can give include charging any debt owed by the company to the director with the director's liability, or changing the order of priority of debts. Again, in the case of multiple directors, liability will generally be several, but the court does have discretion to make it joint and several in respective part or all of the sums. So causation next. Something more is required than a simple but-for causal link. It must be shown that on the balance of probabilities, loss would not have resulted if the defendant had complied with his duties. And there may be wrongful trading if a company incurs further debts, but also if it depletes its assets. the increase in net deficiency requirement. This is a key topic in wrongful trading, and whilst it has been mentioned and a feature of the case law in the past, the leading decision is now in Re-Rouse Builders Limited. And that has taken as authority for confirming now that the remedy will only be granted if there has been an increase in the net deficiency requirement. That in practice means that the court will measure the company's net deficiency at the moment of truth point and will measure the net deficiency at the point of actual insolvent liquidation or administration. If there has been an increase in that net deficiency of assets in that period, then that is prima facie the law. So there will be no order, no remedy if there hasn't been an increase. Similarly, the increase will be the ceiling on any recovery. And there you have, as a causation point, losses which would have occurred in any event as a result of the company going into insolvent liquidation or administration should not be laid at the door of the directors, because those costs would have been incurred in any event if the company had gone into insolvent liquidation or administration at the moment of truth point. So there are assessment problems with the net deficiency requirement. Quite frequently, you'll have cases where the books and records are in a terrible state, or the office holder simply can't get hold of the books and records. So what is one to do in those circumstances? Well, Repur Point Limited provides one answer to this. In that case, it was impossible due to the failure of the director to ensure proper records were kept to do that net deficiency requirement calculation. And in that case, the court decided that the appropriate remedy was to order the director to pay a sum totaling the total of the debts incurred during the wrongful trading period. But be cautious, because this is not a backup in all cases. In Brooks and Armstrong, for example, the court simply refused to go down this route on the basis that the liquidator's calculations were and investigations were simply inadequate. And Mr. Justice Snowden has emphasised that the wrongful trading provisions are not aimed at punishing directors for keeping inadequate accounting records. And that, of course, is the effect in many cases if one will default to ordering the repayment of all debts incurred during the wrongful trading period. So what of the liquidator's costs and expenses? Well, you cannot recover the liquidator's costs in investigating and pursuing the wrongful trading claim as a type of damages for the wrongful trading. And that is because, firstly, costs are not normally recoverable as damages in any area of law, and there's no special cost role for a liquidator. In practice, that actually means that wrongful trading claims are less attractive to liquidators to bring, and particularly wrongful trading claims where there is a small recovery likely or a finely balanced recovery are less attractively brought. And that's because one has to factor in the likely cost of the investigation, which will effectively come out of the pot rather than be awarded in damages. Limitation. So a wrongful trading claim is a claim which falls within Section 9 of the Limitation Act. the cause of action arises when the winding up order is made because it is a liquidator or administrator claim. It's likely that Section 214 does have extraterritorial application. However, the courts will have a broad discretion on that, so one would have to consider the arguments pointing to the links in this jurisdiction as against links elsewhere. So by way of summary then, the difficulties in a Section 214 wrongful trading claim include there's a high hurdle for showing there's no reasonable prospect of avoiding an insolvent liquidation. Secondly, one has to show that the company is balance sheet insolvent at the point of insolvent liquidation or administration. And thirdly, there has to be a causal net deficiency. Well, thank you very much for listening to the wrongful trading element of the webinar. I'm now going to hand over to my colleague, Olivia Wybraniec, who's going to talk about the overlapping duties before we come back to me, and I will discuss the impact or likely impact of the COVID-19 reforms in this area.
So liability for wrongful trading is, of course, not the only basis for personal liability of directors of insolvent companies. And for the next few minutes, I'm going to run through some of the principal bases of liability for company directors at play in the insolvency context. And none of these have been suspended alongside wrongful trading. I'm going to focus on the creditor's interest duty, preserved by Section 172 of the Companies Act, and then look a little more briefly at misfeasance, fraudulent trading, and disqualification and compensation orders under the Company Directors Disqualification Act. I focus on the creditor's interest duty because it's perhaps the most closely related to the prohibition on wrongful trading, and the duty most referred to by critics of the temporary suspension as giving a false sense of security in the absence of suspending other directors' duties, and I certainly count myself amongst those critics. The creditor's interest duty was enunciated in West Mercia Safetyware, whereby a director is under a duty to consider and act in the interest of creditors when they know or ought to know that a company is or is likely to become insolvent. This was then expressly preserved in Section 172 of the Companies Act by subsection 3, although the trigger of insolvency remains a common law rule, which we will look at in a little more detail in a moment. Further, liability under the creditor's interest duty is a civil liability. Just a note here on some of the key differences between the creditor's interest duty and wrongful trading. Well, there's no proposal to suspend the creditor's interest duty under the coronavirus emergency legislation. The threshold for triggering the creditor's interest duty is knowledge that the company is likely to become insolvent, which is lower than the threshold for wrongful trading, which requires there to be no reasonable prospect that the company would avoid going into insolvent liquidation or administration. Further, the creditor's interest duty comes into play when a company is either balance sheet or cash flow insolvent, whereas wrongful trading applies to balance sheet insolvent companies. So in those respects, the duty to consider the interests of creditors is probably more easily engaged than under the wrongful trading provisions. The current authority on the precise point at which the creditor's interest duty is triggered is the Court of Appeal decision in BTI and Sequana in the unanimous judgment given by Lord Justice David Richards. However, a word of warning that the Supreme Court has given permission to the claimants to appeal on this question. As at the beginning of June 2020, that appeal has not yet been heard, so do watch this space. Lord Justice Richards set out a number of points of common ground between the parties in Sequana that had been identified at first instance by Mrs. Justice Rose, and which are helpful in defining the scope of the duty and the consequences of its breach. Probably the most useful of these are that there is a single threshold for when the duty arises for all decisions by directors, that the content of the duty does not vary according to the degree of risk of insolvency, and that a complete failure to have regard to the interests of creditors is not necessarily a breach of duty if it can be shown that the same actions would have been taken if the creditor's interests had been taken into account. The key dispute is what is the exact trigger point for the duty. It was not in dispute that the duty comes into play at some point before the company is actually insolvent. As put by Mrs. Justice Rose, something short of actual insolvency is sufficient. The question is, how close to insolvency does the company have to be? In Sequana, at first instance and in the Court of Appeal, the claimants argued that the duty is triggered when there is a real as opposed to remote risk of insolvency. In his judgment, Lord Justice Richards undertook a quite painstaking analysis of the authorities and identified 4 possible trigger points. These were actual insolvency, when the company is on the verge of insolvency, when the company is likely to become insolvent, or, as advanced by the claimants, where there is a real risk of insolvency. The claimant's contention that the trigger should be the real as opposed to remote risk of insolvency was rejected by Lord Justice Richards as being contrary to policy considerations and contrary to other parts of the Companies Act, in particular as discouraging directors from taking risks. The formulation of the trigger favoured by Lord Justice Richards is that the duty arises at the time that the directors know or should know that a company is or is likely to become insolvent, further clarifying that likely means probable. So, as things stand, the trigger for the creditor's interest duty is the point at which the directors know or should know that the company is or is likely to become insolvent. However, as I said earlier, the claimants do have permission to appeal this point in the Supreme Court, so it is a possibility the Supreme Court will determine that the lower threshold contended for by the claimants of a real risk is the correct trigger for the duty. And we can see clearly how this issue might affect applications arising out of COVID-19 related insolvencies, as if the Supreme Court accepts the lower threshold, this would potentially entail an earlier trigger of the duty to consider creditors' interests and a greater period of liability for the breach of that duty. Just a few final words on the creditor's interest duty. In order to establish breach of the duty, the applicant must demonstrate an absence of good faith by the director, which is a higher threshold than required to establish wrongful trading. As to whether the interests of creditors is a paramount consideration, Lord Justice Richards in Sequana has said that that depends on the facts of the case, but made it quite clear that when the company is actually insolvent, it is hard to see that creditors' interests could be anything but paramount. Finally, in general, the test for breach of duties under Section 172 is subjective. However, in HLC Environmental Projects Limited, a case in which 3 Hare Court's Tom Rowe QC appeared, it was determined that if there was no evidence of consideration of interests of creditors, the test is then an objective one, whether an intelligent and honest person could reasonably have believed the transaction was for the benefit of the company. So, directors will still have to comply with their duty to consider the interests of creditors when the company is or is likely to become insolvent, and act in good faith in light of those considerations, notwithstanding the temporary suspension of wrongful trading provisions. Turning more briefly to the other main bases of personal liability for directors, we have misfeasance and breach of fiduciary or other duty under Section 212 of the Insolvency Act. These claims are usually brought by a liquidator, but can be brought by a creditor or contributory, although more likely a creditor will apply to the court to review a liquidator's decision not to bring an application under Section 168(5). A claim in misfeasance can be brought against a director, as well as against a former liquidator or administrative receiver, and is subject to the Section 1157 defence in the Companies Act. Further, the court has discretion as to the order made, which includes whether an order is made at all, as well as the amount of the order and any interest awarded. Directors also remain liable for fraudulent trading, which unsurprisingly entails a higher threshold of culpability than for wrongful trading. Directors may be subject to civil liability for fraudulent trading under Section 213 of the Insolvency Act, or criminal liability under Section 993 of the Companies Act. The two provisions are broadly the same in effect, but subject to the civil and criminal standards of proof respectively. It's not only directors that might be found liable for fraudulent trading, but any person who was knowingly a party to the fraud. This might include an actively involved holding company, a creditor, or a bank. However, for criminal fraudulent trading, the person must have performed a managerial role in the company. Although there is a higher threshold to establish fraudulent trading, in times when wrongful trading is not suspended, an application can be brought under the provisions of Sections 213 and 214. And finally, directors may be disqualified under the Company Directors Disqualification Act 1986 and made the subject to compensation orders. Disqualification might be ordered by reason of a finding of fraud under Section 993 of the Companies Act or 213 of the Insolvency Act, as already discussed. Or alternatively, and with broader scope, the court is under a duty to disqualify unfit directors of insolvent companies. The matters to be taken into account in determining unfitness are set out in Section 12C in Schedule 1 of the Act, and plainly take into account all of the bases of directors' liability that we have just discussed. Additionally, determinations in relation to reviewable transactions or transactions defrauding creditors, with particular reference to the extent of a director's role in those transactions, may give rise to a finding of unfitness. If a finding of unfitness is made, the court must disqualify the director for between 2 and 15 years, and also has the discretion to make a compensation order against the director under Section 15A, if their conduct has caused loss to the creditors of the company. So against that background of ongoing duties and liabilities for directors of insolvent companies, I'll pass back to Helen Pugh for her views on the effect of the temporary suspension of wrongful trading and some concluding thoughts.
The COVID-19 reform of wrongful trading then. We've been expecting this since the 28th of March. It was the only firm announcement made by the government at that stage. We now have the draft wording and the draft corporate insolvency and governance bill, and the suspension or reform is going to last either from the 1st of March, so it will be retrospective, to the 30th of June, or 1 month after the bill has passed, whichever is the latest. It's currently looking like the bill won't be passed until the end of June, and so the expectation is that this reform will endure until the end of July. The wording is as set out on the slide, and it is that in determining the liability, the contribution, if any, to a company's assets that is proper for a person to make, then the court is to assume that the person is not responsible for any worsening of the financial position that occurs during the relevant period. So notwithstanding the announcements and the title to Section 10, it is not actually an entire suspension of wrongful trading. Rather, it affects the compensation which is otherwise payable. So directors should be aware that there might still be the risk of a tarnished reputation, particularly if there was wrongful trading before and wrongful trading afterwards. It will look like there's wrongful trading throughout that period. It will simply be that the director is only liable to compensate for the net deficiency that occurs before and after the COVID-19 period. Secondary legislation may yet extend the deadline beyond the end of July in any event. There are a number of exclusions. As expected, insurance companies, banks, and other financial institutions are not able to take advantage of the reform. An exclusion to parties to a capital market arrangement might have quite significant repercussions for larger companies, part of a group who have often taken advantage of the debt bond market. There is some scepticism in the insolvency community, I think it's fair to say, about the practical effect of this suspension. And I think many query whether it's really been headline grabbing, but actually a reform of little substance. As Olivia said, the directors continue to be subject to their ordinary directors' duties. The disqual regime applies, and the usual antecedent transaction and unlawful dividends provisions all apply as well. So the real question then is, why has the government reformed wrongful trading at all if it has left other areas untouched? Or conversely, can we rationalise why one area has been reformed and not the other? And as Olivia said earlier, the real key to the difficulty is to consider the creditor's interest rule, which kicks in first in time. So once the company is likely to be insolvent, the creditor's interest duty applies. There is an argument, I think, that reforming all areas of directors' duties and directors' liabilities could provide a license for bad behaviour, but it's quite curious to my mind why it's considered acceptable that a director can increase the net deficiency in circumstances where an insolvent liquidation or administration is considered inevitable. Does not seem to be targeting those companies who are who have an uncertain future, or who have the promise to trade out. So trying to rationalise the reforms then, I've asked myself whether the defence in section 1157 could be the answer. So has the government assumed that directors who decide to trade through the pandemic in the belief that they will have a viable business afterwards, has it been assumed that they have a honest and reasonable belief defence? Of course, as I said before, this is a defence to a director's duty breach, but is not a defence to a wrongful trading claim. So has it been assumed that this defence is going to absolve directors of liability for breach of directors' duties? And I think, to my mind, they would need to believe that the company was not just viable at the end of the pandemic, but would be able to pay back and discharge any debts incurred and losses incurred during the pandemic. So that might be by selling assets in normal times, access to new finance, or from trading profits. But if that's true, if that's the theory, then I don't think it's obvious at all to insolvency professionals or to directors that this is the assumption that's been made. Nor is it necessarily the assumption that the court's going to make if you find yourself as a director facing a accusation that you breached your creditor's interest duty. So I still think that a reform to 1157 could have easily been done and ought to have been done if this was the assumption behind the government's reform of wrongful trading only. The other question mark over this as the answer is that if a director has an honest and reasonable belief that the business will be viable post-pandemic, then they're probably not wrongfully trading, because they won't have reached the moment of truth where insolvent liquidation becomes inevitable. In which case, why reform wrongful trading at all? So if 1157 is the answer, I don't think it's a particularly strong one. So the second matter I considered is whether the content of the creditor's interest duty could be the answer. So has the government assumed that the creditor's interest duty will be readily satisfied by a decision to continue trading rather than to liquidate? And for this, you have to assume that the realizations of assets in an insolvency in this climate is going to be very challenging, and if anything, a sale or the attempt to sell an entire business as a going concern would lead to catastrophic realizations for general creditors. But if this is so, then in my view, we require legislative reform to the statutory duties to make it plain to directors that if they determine that a continuing to trade decision is better for the general creditors, because realizations will be better further down the line, and that will outweigh the costs of continuing to trade, then if that is the excuse that the government thinks is acceptable, then that should have been built into a temporary form of the statutory duties. So, trying to be optimistic about the reform, it signals a change in legislative priorities from an overriding concern for the general creditors to really trying to encourage insolvent businesses to trade through the COVID-19 crisis if they were viable before. The hope is that they can survive and be viable after. Wrongful trading reform does not only apply to COVID-19 affected businesses, it's a blanket reform, albeit a temporary one. But of course, it's much more likely that the overlapping areas are going to trigger liability for directors if the business was already insolvent prior to COVID-19 or has not been significantly affected by the COVID-19 pandemic. The reform probably signals a change in what the legislator will consider honest and reasonable behaviour, and it possibly signals a change in what the creditor's interest duty requires. So what advice should directors be given at the moment? Well, in my view, all these remain relevant. Consider engaging with general creditors, take professional advice, do your financial analyses on different scenarios. Very difficult for directors at this point in time to know when the lockdown will fully end and what customer behaviour is going to be like. And so it will be necessary, in my view, to carry out financial analyses on a number of different hypotheses and at least show that thought is being given to these issues. Document. The directors must be encouraged to write down their reasoning. But by way of summary, if you were teetering before the 1st of March, then this reform has probably only bought you a little time. And if you were insolvent before and have been little affected by COVID-19, and then you are at risk of breaching your creditor's interest duty during the relevant period, notwithstanding that you are not liable for any increase in the net deficiency. So final comments then. How relevant is this? Well, a quick Westlaw case search shows that there have been only 20 reported decisions in the last 10 years, and many of them concern multiple decisions within the same case, the same matter. So in terms of legal jurisprudence, it's unlikely this is going to be hugely significant, I say famous last words. However, from a practical point of view, the reason a director often makes the decision to put a company into insolvency and into liquidation is because of the risk of wrongful trading. So it might encourage some less cautious behaviour. If it's taking industry experts hours to rationalise this reform, then in my view, something's gone wrong with the reform. The aim should always be for the director himself to easily understand where the line will be between reasonable commercial risk-taking and personal liability. It's likely that the IPs are going to be busy, particularly towards the end of July. So directors should be starting to look into the financials now and taking early advice. And there's a new option of a moratorium, which of course might be of relevance to companies who need that extra bit of help and need a bit of time to renegotiate with creditors or to consider a CVA or other type of restructure. So that concludes our first webinar. Thank you very much for everybody for listening. Thank you to Olivia, my colleague, for her part. Our details are set out on the slide. If you have any questions or queries, then please do not hesitate to contact us.